Hello and welcome to today's Navigating USPTO Pilot Programs webinar. Please bear with us while we do a quick audio check. Hello, Larry.
Yes.
And hello, Brett.
Yes.
Thank you both. My name is David, and I'll be in the background answering any WebEx technical questions. If you experience technical difficulty any time during this WebEx event, please submit your technical issue in the Q&A panel to the right of the screen, and I will assist you. Please note that as an attendee, you are part of a larger audience today. However, due to privacy concerns, the attendee list is not displayed. All attendees will be in a listen-only mode for the duration of today's call, and as a reminder, this call is being recorded. With that, we invite you to sit back, relax, and enjoy today's presentation. I'd now like to introduce your first speaker for today, Larry Aronson. Larry, you now have the floor.
All right. Welcome, everybody, to the webinar. Before we start, I just want to go over some quick housekeeping matters. First of all, note that all registrants for today's webinar will receive an email from MBHB within 24 to 48 hours containing a PDF copy of the PowerPoint and a link to an archived audio version of today's presentation. For those participants seeking CLE credit for today's presentation, please note that there are two randomly placed PowerPoint slides inviting participants to complete a simple online poll question. You must complete both poll questions in order to confirm your active participation and thus be eligible to receive CLE credit. We encourage you to submit any questions you may have during the webinar presentation using the WebEx online question submission module. Time permitting, we will attempt to address the submitted questions at the end of the webinar, but if time does not permit, we will respond online after the webinar. Thanks. All right, so today we're going to discuss several USPTO pilot programs. The focus of our discussion is going to be on the nuts and bolts of each of these programs, namely how the programs operate from the perspective of applicants. We're also going to touch on the history of each of the programs briefly, and we'll provide some useful tips and stories related to the programs. The programs that we're going to be addressing are listed here: the First Action Interview Program, AFCP Program, Pre-Appeal Brief Review Request and Conference Pilot Program, and the Motions to Amend Pilot Program. Note that our initial webinar announcement listed some additional programs, some of which are permanent PTO programs rather than pilot programs, so we're not going to be touching on those. If time permits, at the end of the presentation, we will briefly discuss some of those and some abandoned pilot programs. So first off, the First Action Interview Pilot Program. So what is this program? As noted here, this is a pilot program that facilitates an interaction between the applicant and the examiner before the examiner provides a first office action on the merits. So the program allows the applicant and the examiner to conduct an interview after the examiner has evaluated the application, but before the examiner provides the applicant with a first action on the merits. Note that without this program, the opportunity for an applicant to conduct an interview before a first office action on the merits is pretty limited. The MPEP provides a section at 71302 that addresses interviews before a first office action, and that section explains that interviews at that stage would normally be granted in continuing applications, but in a regular non-continuing application, if an applicant requests an interview, the examiner in that situation could require the applicant to provide citations to the closest prior art and to identify distinctions over the art, which is probably not so desirable from an estoppel standpoint. And also, it seems a bit unclear how an applicant would time that correctly to be able to have an interview after the examiner has evaluated the case and yet before the examiner has provided a first office action. The First Action Interview Pilot Program facilitates that. So brief history, the FAI program was introduced initially in select art units in 2008. Then it was enhanced with some changes to the rules in 2009, and it was made a full program accessible to all art units in 2011, and it remains applicable today. The program is applicable for any non-reissue and non-provisional application, and that includes any applications filed directly in the U.S. under 111 or national phase applications under 371. As also noted here, the FAI program has been really used very little. The extent of use is less than 1% based on the data that we've been able to obtain. And so as a result of that, The typical applicant probably is not familiar with the program, or the details of how it works, and the typical examiner also is probably not familiar with how the program works, which, as we'll see, could give rise to some issues in the operation of the program. We have a lot of experience using this program. We have at least one very large client for whom we have used the program in every case since almost the start of the program. So we'll be explaining some things based on our experience. So this slide provides a general overview of how the FAI process works. And as you can see here, the process starts with the applicant first enrolling in the program. And then when the examiner takes up the case for examination, the examiner is going to carry out the same normal restriction and searching process that the examiner would normally carry out for a non-FAI case. So just like in that case, at that point, the examiner could possibly provide an allowance, which would be a first action allowance. But assuming the examiner doesn't allow the case at that point, then under the FAI program, the examiner would then provide the applicant with a communication that the FAI program calls a first action interview pre-interview communication. And in that document, the examiner sets out rejections and objections that the examiner thinks would be appropriate for the examiner to make in a regular office action. But the key point here is that this all happens before the examiner has provided a first office action on the merits. So once the applicant gets that pre-interview communication under the program, then the applicant could prepare and file remarks and proposed amendments together with an interview request. And the applicant and the examiner would then conduct an interview to discuss both the proposed rejections or objections the examiner provided and the applicant's arguments and possible amendments. And again, all of this is happening before there's a first office action on the merits. And then under the program, that interview could result in agreement on allowability, in which case the case would be allowed, or not. And if it doesn't, one thing that could happen at that point is that the examiner would then provide the applicant with a document called a first action interview office action. And that would be the first office action on the merits. And then normal prosecution would proceed at that point. So all of this happens before the first action on the merits. So in the next slides, we're going to talk about some of the specifics of these steps of the process. So the first step in the process, as I noted, is for the applicant to file a request to enroll in the program. The PTO provides a form. It's called the Request for First Action Interview Full Pilot Program form. It's shown here. It's Form PTO SB 413C that the applicant should use for this purpose. And it's a pretty straightforward form. It says that the applicant is requesting a first action interview, and it also states that the request being submitted complies with the requirements of the program. And those requirements are that the application can have no more than 20 claims and no more than 3 independent claims, and the application cannot include any multiple dependent claims, and also that the applicant is agreeing at this stage to make an election without traverse if the examiner provides a restriction requirement. Now, the rules of the FAI program require that you file this request form at least one day before the first office action shows up on PAIR. So our practice to play it safe, and we recommend this, is to file the request at the time we file the patent application. You could, however, file it afterwards. There are several things that you should keep in mind when you file a request to enroll in the FAI process. First of all, EFS has a special group of document descriptors for the FAI pilot program specifically, and in that group there is one called First Action Interview Enrollment Request. That's the one you should use for this. Also, if your request does not comply with the requirements of the program, then the PTO is going to provide you with a notice of notice of noncompliance, and you're going to have 1 month to fix the problem. If your application does not have the right number of claims, if it's too many claims, you could file a preliminary amendment to fix that issue before you file your request, and then you can, or in terms of fixing a non-compliant request. Also, in terms of multiple dependencies, if your application that you're filing in the U.S. is a national phase application or one based on a foreign case, be careful to ensure that there's no multiple dependencies, which might happen as a result of the source of the application. That would not be compliant. And lastly, just to note that if your request is compliant, the Patent Office is not going to issue any communication or notice of acceptance of the request. So the assumption is your request is accepted unless you get a notice of noncompliance. Now, assuming you have filed a proper request to enroll in the FAI program, the rules provide that the examiner would then take up the case in the normal order and would carry out several steps as shown here on this slide. So first, the examiner is going to apply the normal restriction practice that the examiner would normally apply to determine whether there's more than one invention that's claimed. And as noted, if the examiner provides that restriction requirement, you are required to elect without traverse under the program. I will just note that there have been several instances where we've received restriction requirements in this program and where the requirements are plainly incorrect, where maybe the examiner has just literally clearly misread the claim language. In those instances, we have talked with the examiners to try to get the restriction requirement removed and successfully done that. But in those instances, we've also made it very, very clear that we are not traversing the restriction requirement. We're just pointing out these issues with it, which I guess is kind of on the borderline, but we're saying we're not traversing it. And anyway, that's how we've handled that. Anyway, after any restriction process, the examiner is then going to search and evaluate the case as normal. And if the examiner decides that the case is allowable, then the examiner could provide a first action allowance. But if the examiner decides at that stage that the case is not allowable, then the examiner will provide a communication under the program that's called a first action interview, pre-interview communication, as I noted. And that the examiner will provide that along with the list of references cited. Now, here's an example of what that pre-interview communication looks like. So as shown here, the communication is structured as kind of a table format, and it provides spaces for the examiner to specify the claims, the references and the statutory basis for the rejections or objections, and then small spaces for the examiner to provide a brief explanation of the basis for the rejection or perhaps objection. The form also provides some spaces below then for an expanded explanation of any rejection basis or objection. And there's also continuation sheets that the examiner could use. Now, in many cases, in the ones that we've handled, we've seen a variety of level of detail provided in these forms. This is clearly different than a regular office action in terms of the format. Oftentimes, examiners provide relatively little detail here, but examiners do provide a mapping typically of claim elements to portions of the cited references. Sometimes, on the other hand, examiners provide very, very detailed pre-interview communications, filling in all of the spaces and using multiple continuation sheets, or sometimes even providing an attachment that is the kind of format that you would see in a regular office action. So in any event, once the applicant receives that FAI pre-interview communication, the applicant then is going to consider the strategy and will respond to the pre-interview communication. And according to the FAI rules, the applicant has 1 month to respond, and that's extendable for 1 month. And as shown here, the rules allow for 3 possible responses to the FAI pre-interview communication. The applicant can request an interview and provide a submission, and we'll talk about in a moment. Or the applicant can respond under Section 111, 37 CFR 1.111, waiving the first action interview and the first action interview office action. Or the applicant can request to waive the interview, which the applicant could do by just not responding at all. The most common response to an FAI pre-interview communication is for the applicant to file proposed amendments and arguments, or just proposed arguments, to address the examiner's rejections or objections. And preparing this submission is pretty much like preparing a response to a normal office action. So here you can provide amendments and arguments to help overcome the examiner's stated proposed objections or rejections as you feel would be necessary. But keep in mind that what you're doing at this stage is you're proposing amendments and arguments, and you're working to move prosecution forward in a good, productive way. So although you're submitting what you would, similar to what you would if the examiner had provided a regular office action, this, again, is all preliminary before the first office action on the merits. So given this, there are some things that you should keep in mind when you write your remarks. First of all, we generally refer to any rejections or objections that the examiner set out as in terms of the examiner having stated that the claims could be rejected on so-and-so grounds or could be objected to on so-and-so grounds, rather than that the examiner rejected or objected the claims, because, again, this is all very preliminary and is not an actual rejection or objection yet. By the same token, in terms of characterizing the proposed amendments that we provide, we say that applicant proposes to do so-and-so, to amend the claims in so-and-so way. One note here, we think it's okay to argue that at this stage the examiner did not establish prima facie unpatentability, like didn't establish prima facie obviousness. But be prepared for an examiner to respond to that argument, though, by stating that the examiner doesn't think there's really a burden to meet the prima facie burden at this stage. And you need to be prepared to discuss the merits of any distinctions over the cited art, aside from not establishing prima facie obviousness. I mean, again, keep in mind that this is an effort to try to reach agreement with the examiner at this stage. So while probably the prima facie burden applies here, I don't know of a reason why it doesn't. You still need to be prepared to address the examiner's assertion that it doesn't apply. And just keep the goals of the process in mind here. Try to educate the examiner and set the examiner on a good stage, good path forward. And also, in cases where the examiner provides very little in terms of remarks on the pre-interview communication, if you do a good job of educating the examiner and explaining to the examiner what the situation is and why the case should be allowable, there's a chance the examiner may appreciate your assistance at this stage and may be more likely to allow the case quickly if appropriate. One last note is indicated on the bottom of the slide. The rules require that in your submission you need to mark every page with the term proposed to indicate that these are proposed arguments or amendments. This slide shows an example, genericized example of a cover page and an example footer. And if we were to just only be providing arguments, we would say proposed arguments instead of proposed amendments and arguments in the title and the footer. So once you've prepared your proposed amendments and arguments, or just proposed arguments, then under the FAI rules, you would work with the examiner to arrange for an FAI interview. And you would file an interview request together with your submission that you put together. And to arrange for this interview, we usually call the examiner and try to reach an agreement on a date and time that would work for the interview. And there are several things you should keep in mind at this stage. First of all, you need to schedule the interview to occur within 60 days of the interview request. That's unlikely to be an issue. We never have that issue because we schedule these usually within a week-ish after we file the request. Also, you should try to confirm that the examiner will review the submission that you're providing to help make the interview as productive as possible. And in that regard, when you're talking with the examiner, you should tell the examiner that you're providing these proposed arguments or proposed amendments and arguments, and explain that they're going to be attached to the request, the interview request, and that they function as the agenda. Otherwise, examiners are often questioning whether you're providing an agenda. That is the agenda. And you can also offer to send a copy of your submission to the examiner by email. Examiners usually appreciate that a lot. And once you've agreed on a date and time then for the interview, you're going to file your interview request together with your proposed amendments and arguments or proposed arguments. And there are a couple things to keep in mind here. First of all, the rules that require that you provide your interview request with your submission. So you should combine them as a single document. We usually generate a single PDF, the first page of which is the interview request, and then the pages following that are the submission. And then also you need to file the request by EFS. Although we can say from experience as Patent Center beta testers that you can also file it by Patent Center, and that would work fine. This is an example of an interview request here, requesting an FAI interview, and this is standard interview applicant-initiated interview request form. It's PTO L413A. So there's nothing particularly special here. You're going to enter the information about the rejections and the claims and so forth that you want to talk about. Just to note, though, because this is the FAI program and you're providing your proposed amendments and arguments or the like, we usually say in the brief description of the arguments as shown here that please see accompanying proposed amendments and arguments. And then to file this request, there is a specific EFS document descriptor that you should use. In the group of FAI document descriptors, there's one that says First Action Interview Schedule Interview Request. And that's the one you should be sure to use here, rather than the one that says replying to a pre-interview communication under Section 111. It is possible the PTO may code it as a reply under 111, and we saw that happening a lot in many cases. We used to try to fix that, but we determined ultimately that it didn't seem to matter. So we've just let that go at this point. All right. So that's what we just walked through is the process for responding with a request for an FAI interview. As I noted earlier, there are a couple other ways that an applicant can respond to an FAI pre-interview communication. One is if the applicant, based on the review of the pre-interview communication, has determined that there's some really easily resolvable issues to put the case in condition for allowance, then the applicant can file a regular response. That's a response under 37 CFR 1.111, and that would be effectively then waiving the FAI interview. You wouldn't have an FAI interview, and it would be waiving any office action that would come afterwards, FAI office action. And so this would be effectively converting the FAI pre-interview communication into the first office action on the merits. And we recommend taking this approach if you are pretty sure that the response you would file would resolve all of the issues and would get you to a point of allowability. If there are any issues that the submission might possibly not resolve, such as if you're proposing an amendment that's a little different than what the examiner suggested or something along those lines, then we think it's better to request an interview, as I just walked through, and talk about it with the examiner to make sure. Keep in mind also here that you would need to file this response by 1 month from the pre-interview communication. Even though you're converting it to a first office action on the merits, the pre-interview communication, you still have a month to respond, not 3 months. So you keep that in mind. And also, you should entitle your response in this instance response under 1.111 to pre-interview communication. And in this instance, you would use the EFS document descriptor accordingly that talks about that response under 111. All right, and then the last option as noted here is you could request to waive the interview. We have not taken this approach to my knowledge. I have never done this, and I'm not sure anyone in my firm has done this. Frankly, I'm not quite sure when this would be a good approach to take. Maybe there would be good instances, but we'll leave it at that for now because that's not one that we generally use. So once you've filed your interview request, you're then going to conduct the interview at the scheduled time. And in this FAI interview that you're going to conduct, you should follow the general good interviewing practice. So you could take a look at the USPTO's talking points regarding interviews. And again, keep in mind that the goal here at this stage is to help move prosecution forward on a good path towards allowance, hopefully. And keep in mind that this is all before a first office action on the merits. So even if the examiner won't agree in the interview to allow the case, hopefully you can use this exercise to educate the examiner and to learn about the examiner's position so that you can then move forward on a good path. And one other thing, keep in mind that, as I noted earlier, many examiners are not familiar with the FAI process. So you need to be prepared to discuss with the examiner how the FAI process works, which means you need to be familiar with how the process works. And you need to be able to explain to the examiner the next steps of the FAI process, which we'll talk about on the next slides. And maybe in some instances it would be useful to work with the examiner to continue the interview, that is to have an additional discussion that I would view as a continuation of the FAI interview. Some examiners are happy to do that in situations, for instance, when maybe you have some different amendments or something like that that the examiner wants to consider, which are in the discretion of the examiner to enter, or other things that the examiner wants to look at. And lastly, as noted on this slide, be sure to file an interview summary because this is an applicant-initiated interview. So at the conclusion of the interview, you and the examiner should decide what the result of the interview is going to be. And there are, as I noted, two possible results. Either you can reach agreement on allowability with the examiner, and in which case the examiner would then provide an allowance. If you provided proposed amendments in that situation, the examiner could enter the amendments just by marking them okay to enter. If you provide different amendments to the examiner, maybe something else that you talk about during the interview or the like, the examiner could enter those either as an examiner's amendment, or in some instances examiners have asked us to file a supplemental response, which is technically not really something that would be done under the rules, but examiners have asked for it and we agree in the spirit of cooperation and move forward with that. The other possibility is from the interview that you do not reach agreement on allowability. And if that happens, then you have two possible things that you can do. One is you can agree to enter what you submitted as a response under 111. So you can agree to basically convert the submission that you provided into a response to a regular office action, which would convert the pre-interview communication into a regular first office action on the merits. And if you do that, the next thing you may get from the examiner would be possibly a final office action, because that would be a second office action. Alternatively, you can, if you don't agree on allowability, you and the examiner could agree to proceed with the next step of the FAI process, which is that the examiner can then provide you with a first action interview office action. And this would then be the first action on the merits. Now, this communication, the way it would be structured, would have a summary sheet similar to what you would see in a regular office action, and then it would have sections that look pretty similar to what the pre-interview communication looked like. Depending on how the interview goes, the FAI office action might be identical to what the examiner provided as the pre-interview communication. That's not desirable, of course, because that kind of doesn't help move things forward. So we recommend that you work during the interview to try to get the examiner to agree to provide something more than that. This is an example of the FAI office action. As I said, there's a cover sheet and then similar looking table structured form for the examiner to provide his or her thoughts. So here are some of the reasons why the FAI program could be useful. The program provides an applicant with an extra bite at the apple by allowing interaction between the applicant and the examiner before there's a first office action on the merits. And as a result, the program could help to facilitate quick and early resolution of the case, especially if there are just minor issues to resolve. And the program can also help educate the examiner, and the applicant can learn about the examiner's point of view, which is all good in terms of moving prosecution forward. Also, as noted, it's different than the norm. So this is something that examiners, again, don't often do. And so to the extent examiners are day in and day out doing the same kind of examination, this is a little bit of an aberration, and it might be an interesting thing that perhaps would be desirable for some examiners. Last point noted there, the program is free. So that's a good point. So as I noted earlier, given the rare use of the FAI program, sometimes the program doesn't work the way it should. And we know that the Patent Office educates examiners on how the process works, but if an examiner rarely encounters the program, then the examiner is going to have little incentive to remember the rules of the program. He's going to have to try to figure things out each time the examiner encounters the program. And unfortunately, this leads to some problems in execution. And one of the issues that we've seen, this is the most common issue that we've seen with the program, is that examiners in an FAI enrolled case, an examiner would provide a regular first office action on the merits instead of an FAI pre-interview communication. And this usually happens, it seems, because the examiner doesn't notice that the case is enrolled in the FAI program. And at least one examiner has told us that there's no process in place right now to alert an examiner that a case is an FAI case. So unless the examiner sees it on pair, the examiner may just handle this in the normal way. And so this has happened really in countless applications that we've handled under the FAI process. So our recommendation for handling this is soon after we get that erroneous office action that should have been a pre-interview communication, we call the examiner to discuss the situation, and we explain things to the examiner. And at that point, we offer the examiner typically some options for how we think would be appropriate to proceed. As noted on the slide, one option we offer is for the examiner to vacate the office action and send out a pre-interview communication, as the examiner should have under the program. The other option is to treat the pre-interview communication to treat the office action as a pre-interview communication. And in that case, we would get the examiner to agree, hopefully, that if there is a next action that's not an allowance, that the examiner would make that next action non-final. And that's important because under the FAI program, the next action would be the FAI office action, which would be non-final. And so we're trying to simulate the program. And then we would confirm whatever we talk about with the examiner at that stage in the interview summary. I'm not going to read this slide, but you can take a look at this at your leisure later. This is an example of what we would specify, what we would state in an interview summary to confirm an agreement with the examiner to treat a regular office action as a pre-interview communication under the FAI program. So lastly, just to finish things up, I thought I'd share some entertaining examples of how the FAI program has kind of gone awry in some situations. It's a very, very good program overall, and I will present some points on that in just a second. But these are, I guess I can't characterize this any way other than entertaining. Hopefully you'll find it entertaining as well. So just to walk through these quickly. In one case, this is an example of that most common problem that I mentioned. The examiner provided us with a 58-page normal first office action on the merits rather than an FAI pre-interview communication. So we talked with the examiner, and the examiner agreed to treat that office action as a pre-interview communication. And then we proceeded under the FAI program and ultimately reached agreement on allowability, so that was good. In another case, after we conducted an FAI interview, the examiner then provided us with another FAI pre-interview communication, which is not the way things are supposed to happen. So we talked with the examiner about that, and the examiner explained that he had found some additional art, so he decided to send another FAI pre-interview communication so that we could go through the FAI process again. We questioned it, but in the spirit of cooperation, we reached agreement to do what the examiner wanted to do, and we went through the program again. In yet another case, instead of providing us with a pre-interview communication to start, the examiner provided, as the start of the FAI process, provided us with an FAI office action. So we talked with the examiner, and the examiner then provided us with a pre-interview communication. In still another case, the examiner provided us with an FAI pre-interview communication that included no rejections or objections at all. The form was completely blank. The summary sheet said the claims were allowed, though. And we talked with the examiner, and the examiner said, oh, he wanted us to respond, and then he would allow the case. So we did, again, in the spirit of cooperation. In one other case, the examiner provided us with an interview summary that stated that he would update his search once he receives an official response from us. But under the FAI program, the ball is in the examiner's court at that stage, not the applicant's court. And lastly, in one other example, after we filed proposed arguments in response to a pre-interview communication, the examiner called us and told us that he would prefer to not apply the FAI process with an FAI interview, and he'd rather just provide us with a normal first office action. So we agreed, again, in the spirit of cooperation, because that's what this is all about, cooperating and getting things moved forward with the examiner. I'm not going to go through these, but these are examples of positive results of the FAI program. Overall, the program has been very, very successful in our view and a good program to participate in. Lastly, this slide shows some resources that you can look to get some additional information on the program, and hopefully all of this will help you be able to use the program. So now, for those seeking CLE credit for this webinar, please note that note the one-word phrase that appears on this slide, and please enter that word into the WebEx poll question module. You're going to need to complete both poll questions, this and then the other one that will come later, in order to confirm your active participation and therefore be eligible to receive CLE credit. Thank you. Now over to Brett.
Thanks, Larry. I'll leave this slide up for a few more seconds to give people some time to enter their poll question. We'll also have this poll open for a couple minutes, so while we'll advance off this slide shortly, you'll still have some time to go ahead and enter the poll answer in while we move forward. Okay, so moving on, we're going to start talking about the next program, which is the After Final Consideration Pilot Program. Now it's officially the AFCP 2.0 program because it's been modified, but we'll go through the details over the next few slides. So what is the program? Well, it's a process that gives examiners a fixed allotted amount of additional time to search and consider any amendments that are submitted by the applicant after a final rejection. And then it also gives the examiner time to discuss the results of that search and consideration with the applicant. Now, the purpose of this program is twofold. One is to enhance communication between the examiner and the applicant. Under standard prosecution procedures, once a final office action is issued, any interviews between the applicant and the examiner are pretty much entirely at the examiner's discretion, and they're typically only granted if the examiner believes that the interview would result in quick disposal of the application. So basically, if you can reach agreement on allowance with very little further consideration, then the examiner is more likely to grant an interview, but it's entirely up to their discretion. So this provides a way for the applicant to get an additional interview as of right. And the second objective of the program is to hopefully advance prosecution of your application to the point where the applicant doesn't have to file an RCE if you can get it allowed. And there are a lot of RCEs being filed before the Patent Office, results in longer prosecution and contributes to the backlog before the PTO. So it'd be great if we can have more programs that are designed to reduce these RCE filings, and so the AFCP is designed to try and do that. Some history of the program: it was first introduced in 2012 as the After Final Consideration pilot program. It was tweaked a year later in 2013 to become what it is today, the AFCP 2.0. We'll go through the actual details and rules of what goes into the AFCP 2.0. Since 2013, it's been extended annually, and currently it is active through September 30th of this year. Now, as Larry mentioned, the FAI program is not very widely used. On the flip side of this is the AFCP program. It is extremely prevalent. We did a search of all applications that have received final office action since it was introduced. We found that 25% of all of the applications involve the filing of an AFCP request. This number is probably much higher, though, if you actually only consider the applications that were amended after final. So we were looking at any application that received any final rejection, regardless of whether there was any response filed after final at all. We spoke to one examiner on his experience with this program, and he estimated that around 3/4 of all amendments after final are filed with one of these AFCP requests. So very prevalent. Now, in order to participate in the program, it applies to any non-provisional utility, plant, design, or national stage applications with an outstanding final rejection. It does not apply to reissue or re-exam applications. And if you want to participate in the program, you have to file a non-broadening amendment to at least one independent claim. And you also need to file a certification and request form when you do so, and you file that with your after final amendment. Participation in the program is entirely free, other than, of course, any extension of time fees that you've incurred if you're filing after the 3-month date after final. And those must be paid when you file your request to participate in the program. Here's a quick view at the certification and request form that you have to file in order to participate in the program. Without going through all of the details of the text on the form, I just want to call out a few important things. One thing to note is that the applicant is limited to filing one of these requests per final office action. So if you file AFCP request and your request gets denied for one reason or another, you can't subsequently file another one unless you go through another round of prosecution and receive an entirely separate final office action. Second, as part of this form, the applicant has to agree to participate in an examiner-initiated interview. As I mentioned earlier, the point of this program is to improve communication between the applicant and the examiner, so the applicant needs to be willing to participate in an interview. And then finally, one more important thing to note is that this must be filed using EFS Web, so you cannot participate in this program if you're paper filing. Presumably, filing this via Patent Center would also work as well. So now we have a flow chart illustrating how the program actually works. Apologies for the formatting on some of these. Looks like we had some text wrapping issues. But starting on the left here, the applicant will submit the AFCP 2.0 request with its response to the final office section and with the non-broadening amendments. The examiner will receive this request and will first evaluate to determine whether it complies with the AFCP rules. So whether there's the amendment is non-broadening, whether it was filed via EFS Web, and whether the applicant has not previously filed an AFCP request in connection with this office action. If the request does not comply with the rules, the examiner will issue an advisory action. If the request does comply, then the examiner will move on to consider, to evaluate whether the non-broadening amendment can actually be considered within the examiner's allotted time. For utility and plant applications, the examiner is allotted a total of 3 hours, and that's broken down into 2 hours to do any search and consideration of the amendment and arguments, and then up to 1 hour for interviewing the applicant to discuss the results of the search and consideration. For design applications, the examiner is given much less time. They only get 1 hour to consider, and then an undefined amount of interview time, however long it takes to discuss the results with the applicant. Now, this stage is entirely in the examiner's discretion, and so if you participate in this program and get rejected, this is most likely where you're going to get your request denied. Now, one thing that the examiner can, so 3 hours for a utility application is very, very little time to consider any substantive amendment to the claims. And this is entirely in the examiner's discretion. And one other thing the examiner might be considering when making this determination is that if they reject this request, it may force an RCE, which could potentially be more beneficial to the examiner's count requirements as well. So at this stage, if the examiner rejects the request, again, they will issue an advisory action, and then the procedure ends. Alternatively, if the examiner determines that the amendment can be considered within the allotted time, it moves on to the next step where the examiner considers whether the amendment and arguments places the application in allowable condition. If the examiner finds that the application is still unallowable, at this point the examiner will schedule the interview with the applicant to discuss the results, and after the interview will issue an advisory action. Alternatively, if the application is now in allowable condition, then the examiner will just go ahead and issue a notice of allowance. So with that in mind, an important question to ask is, does this program work? Well, the Patent Office has said that they're still collecting and evaluating data on the program, so they don't have any official data to indicate whether it achieves one of the two stated goals I mentioned previously, but they have done surveys, and regardless of whether or not the program is actually effective, they found that the majority of applicants feel that it is effective in advancing prosecution and reduce their likelihood of filing an RCE. Now, we attempted to do our own independent analysis of publicly available data. We use a tool called Jurastat. It's a really great tool for accessing USPTO statistics. Based on the data we found, it's pretty inconclusive. We found that for all applications in which a final office action was responded to, compared to applications where the final office actions were responded to with an AFCP request, they have pretty similar RCE filing rates. So it's not clear whether the AFCP program is actually reducing any RCE backlog. One thing we did notice is a reasonable increase in the allowance rate, about a 10 to 15% increase in the allowance rate for those applications that were filed with an AFCP request compared to the entire pool of applications that responded to a final office action. It wasn't clear whether there's causation here or just correlation, but it was interesting enough to note. So some practice tips for those of you wishing to participate in the program. We recommend using the AFCP 2.0 program for amendments that can be considered without extensive search and consideration. As I noted previously, the examiners are given very limited amount of time to consider these amendments. And so anything that is going to be a major change to a claim something that the examiner hasn't seen before, it's very likely that you're going to get rejected under the rationale that your amendments cannot be considered within the time allotted. So any minor amendment that does not drastically change the scope of the claims it'd be worth trying to participate in this program. One strategy that I like to use when doing this program is if I find that there's a dependent claim that was pretty weakly rejected and that the applicant finds valuable, I will amend that really weakly rejected dependent claim into the independent claim. And I will note that in the off-section response that I'm really just incorporating language here that the examiner has already considered when issuing the previous office action. So this isn't really any new amendment that the examiner doesn't have additional time to consider because the examiner has already considered it. So that kind of places it places the examiner in a tough position to reject it under the rationale that they don't really have time to consider it under the program. On the flip side, any major amendment that would change the scope of the claim, don't do that. The examiner they won't have time to consider it. Also, for really minor amendments, things that are only addressing formalities, like say the examiner objected to a dependent claim as being allowable, or rejected it under a 112 issue and provided recommended amendments that would resolve the issue. For things that the examiner doesn't have to give any consideration to at all, there's really no point in filing those amendments under this program. The examiner won't get any extra time under the AFCP to consider those amendments, and so you're really just adding more unnecessary work to the applicant to prepare and file the request under the program. Next, we recommend if you reach the stage where you're getting an interview with the examiner, at this point you're going to receive an advisory action because the examiner has determined that your amendments don't place the application in condition for allowance. So we recommend using this interview to develop an RCE strategy. Make sure you get a strong understanding of the examiner's view of the prior art. If they've uncovered any new references as part of their search and examination and consideration, take note of those references and give them some consideration when you're preparing any amendments that you're going to file in an RCE. Also, if you have any amendments in mind, or even if it's just at a high level, I like to run those by the examiner at this stage just to get some either informal or formal opinion on whether those would overcome any art that the examiner found. And then finally, our last tip is to file early. Examiners are encouraged under this program to respond as soon as possible, but it can take over a month sometimes to get a response under this program. So if you're unable to file by the 2-month date after final to prompt an advisory action, then we recommend filing as early as possible to avoid incurring any additional extension of time fees while you wait for the examiner to evaluate the program or the response under this program. So with that in mind, here are some additional resources that you can look into if you're interested. The official Gazette notice and the USPTO's AFCP 2.0 page has got some great FAQs on there for applicants. And with that, I'll hand it back to Larry to talk about the next program.
Thanks, Brett. All right, so next we're going to talk about the pre-appeal brief review, request, and conference pilot program. And so what is this program? This is a program or a process that facilitates panel review of an application that's on appeal before the applicant has to prepare and file an appeal brief. And this process could help resolve a case without the need for appeal briefing. This slide shows the normal appeal process and then the variant that arises from this program. So the black boxes show that in the normal process, once your claims have been rejected twice, you can file a notice of appeal, and then you have 2 months to file an appeal brief, after which you may get an answer from the examiner, and then you could file a reply brief, and you need to pay the appeal forwarding fee to send the case along to the board for review and consideration, a possible oral hearing if you requested that. The pre-appeal brief pilot program is set forth in the red boxes here, and this add something on at the time of filing the notice of appeal. When you file your notice of appeal, you can also file with it under the program a pre-appeal brief request for panel review. And from that, three possible results could occur. One is the case could, the panel could direct that prosecution gets reopened, or the panel can direct that the examiner allow the case, or the panel can decide that the case should go along with the normal appeal process, in which case you would then be back to the top part and you would have to file your appeal brief and so forth. Brief history of this program. This pilot program was established in 2005 and then extended in 2006, and it remains applicable today. So this is a 15-year-old pilot, and I guess this is kind of a theme with some of these, that these pilot programs are very long-standing pilot programs in some instances, and they're still deemed to be pilot programs. I think that's probably because they're just not formalized as things that will necessarily be permanent. The Patent Office may be reserving judgment and may be able to remove them easily if they decide to do so. I think this probably will stick, though, in my opinion. This particular pilot program is described in the MPEP in Section 120402. And in terms of objectives, this program can help facilitate efficient review of the case before the applicant, as I noted, prepares and files an appeal brief by allowing the applicant to identify clear errors in the rejections. And the program can, as a result, help the applicant save time and money by possibly avoiding the need for the applicant to go through the process of preparing and filing an appeal brief and maybe other costs down the road. Just to note, this cost savings is, it was more of an issue back before the appeal brief fee went away in 2013. But this program can still provide some very good cost savings by avoiding the cost involved with the time spent preparing an appeal brief, possibly avoiding that. The pre-appeal brief pilot program is applicable for any non-reexamination application. And as noted here, based on the data that we've reviewed, about 12.5% of appealed applications since 2006 have used this program. So here's a brief overview of how the process works. Steps are, first, the applicant would consider and decide whether to request pre-appeal brief review at the time the applicant's going to file an appeal brief, and then notice of appeal, sorry. And then, if so, the applicant would prepare a pre-appeal brief reasons for review document and would file that together with the appeal brief and a pre-appeal brief request for review. The PTO would then put together a panel of examiners, and that panel of examiners will then review the case and decide whether the case should go to the board, should be allowed, or prosecution should be reopened. So to start, if the applicant has decided to proceed with an appeal, then the applicant should consider whether the pre-appeal brief request for review is appropriate. And the question here is whether the applicant believes that the examiner has clearly erred in rejecting the claims. So if the applicant has a good basis to argue that there's a clear error in terms of facts or law in the rejections, then this process may be appropriate. On the other hand, if the issues at hand are matters of interpretation of the claims or the prior art, or otherwise, if it's not so clear, then this program under the rules is not the appropriate route. And instead, the normal appropriate route of filing an appeal brief, notice of appeal, and then an appeal brief would be appropriate. There could be some middle grounds, as noted here. For instance, if the factual basis for the examiner's interpretation is wrong, if there's clear factual error, then maybe that's a middle ground. And in those situations, we would recommend going ahead with the pre-appeal brief request for panel review, because the worst thing that would happen there is that the panel would decide that the case needs to just go forward with regular appeal. But it's possible that you might gain benefit by having prosecution be reopened at that stage. So if you decide to proceed with the pre-appeal brief review process, then the next step would be for you to prepare reasons for review, which you're then going to file together with a pre-appeal brief request for review and your notice of appeal. And a couple things to keep in mind here as noted on the slide. First of all, the document that you're preparing here is your reasons for review. It is not a pre-appeal brief. The descriptor, the term pre-appeal brief, is the descriptor for the process or the request that you're submitting. So it's a pre-appeal brief, reasons for review, or request for review, but the document itself is not a pre-appeal brief. It's not really a brief. In terms of length, the document that you file as your reasons for review needs to be no longer than 5 pages under the rules. You could play theoretically with the line spacing or font size, but we strongly recommend against doing that because the point here is to keep things concise. And so you want to make it easy for the panel. So I would suggest not doing so, not making it smaller fonts or line spacing. So the rules require that the reasons that you set forth be set forth succinctly and concisely. So when you prepare your reasons for review, it's really important to follow that rule. And really, as in any response, try to cut to the chase at the start. Tell the panel up front what the clear error is, and then support that assertion with easy-to-understand arguments. You want to really make this as simple as possible so that the panel can side with you on this. So just like in a conventional response, you can address things like the examiner didn't address an element, or there was no motivation to modify the art, or conclusory assertions, or the like. Also, in your reasons for review, it's a good idea to incorporate by reference your previously submitted arguments, namely the arguments that you submitted in your latest response or responses. And the rules expressly allow for this and, in fact, seem to encourage it. So if you're going to do this, the rules specifically say that you need to refer to the specific arguments. So by section number, line number, page number, whatever it is in your previous submitted responses, you can't just refer to the document as like the response filed so-and-so date. That's not a legitimate incorporation by reference under this program. Also, if the examiner provided any remarks that you didn't yet respond to, such as if the examiner provided remarks in an advisory action, this is a good time to address those because all of that's going to come out in the panel review. So you want to address any of those things at this point. So once you've prepared your reasons for review, the rules then provide that you're going to file a request for review and the reasons for review together with your notice of appeal. So the time to submit your request for pre-appeal brief panel review is when you file your notice of appeal. You cannot do so after the date of receipt of your notice of appeal. And the PTO provides a pre-appeal brief request for review form. That's PTO SB 33 or AIA 33 to be used for this purpose. And here's an example of what that form looks like. There's a slight difference between the SB and the AIA versions, but you can take a look at those and you will see they're pretty much the same. Let's see. Actually, go back to that slide. So the form itself is pretty straightforward, and basically it says that you're requesting review of the final rejection, and you're also not filing any amendment with your request, and you're filing the request with a notice of appeal, and you're providing an attached reasons for review document, which, again, is no longer than 5 pages. So you are making all those assertions when you do this. And here, similar to what I talked about with the FAI program, you should combine things together in a single PDF. So combine your request for review with your reasons for review as a single PDF and file that. And if you file this by EFS, in this case, you should use the document descriptor pre-brief conference request. And again, be sure you do this with your notice of appeal. So under the rules, once you file your request for review, the Patent Office is then going to establish a panel of examiners to review the request. And typically, this panel is made up of the examiner who's examining your case, a supervisory examiner, and also a review quality assurance specialist, which is an examiner who looks for errors and teaches examiners and presents training and so forth. So that's going to be the group, probably. Could be different, but that's generally what we understand is the case. And under the rules, that established panel is then going to conduct a review of the case and is going to provide a written decision of the status of the application based on their review. And again, this is all before you file any appeal brief. So the panel is going to consider the rejections or objections typically, by the examiner and the reasons for review provided by the applicant, and is going to determine whether the examiner clearly erred and whether the prosecution should be reopened or perhaps the case should be allowed. Now, in practice, we understand that when an applicant files a pre-appeal brief request for panel review, the examiner can take a look at this and decide at that stage, before even going to the panel with it, whether the examiner wants to stand by the rejections. And if the examiner decides to stand by the rejections, then the examiner would send it along to the panel for the full review. Otherwise, the examiner may reopen prosecution or potentially allow the case. Also note that the rules specify that once you filed your request for review, you, the applicant, are not allowed to be involved with the panel review process. In particular, the rules do not allow the applicant to attend the panel review, and also the rules don't allow an interview to be granted before the panel decision. So once the panel has made its decision, the panel is then going to provide a notice of panel decision from the pre-appeal brief review, and this shows an example of that. The panel needs to provide this within 45 days of the applicant's request. And as shown here, there are actually 4 possibilities of outcomes. One is that there's a determination that the request was improper, or probably that there's some technical issue with it. 2, that the case should go along to the board. I will note that the form says proceed to the Board of Patent Appeals and Interferences, which I think maybe need to be changed to PTAB instead of the BPAI. In any event, that's one possibility. And in that case, the applicant would then need to file an appeal brief within the longer of 1 month from that decision by the panel, or 2 months from the filing of the notice of appeal. Third possibility is that the panel determines that the case is allowable, in which case they would direct the examiner to do so, and the examiner should do so. And the fourth possibility is the panel says reopen prosecution. And if the panel decides to do that, in that situation, the examiner would then take the case up for further examination. And it is possible, and we've seen in many instances that, not many, but a number of them, that examiners allow the case at that point when they take the case up for further examination. Note also that the decision form doesn't provide any explanation for the indicated decision. The rules specify that the decision will not include any discussion of the grounds for the rejection. So, and also one other note, if the decision is to allow the case or reopen prosecution, the rules make clear that the applicant is not entitled to a refund of the notice of appeal fee that the applicant needed to pay when filing the notice of appeal. But just note, if you do end up appealing the case again at that stage, if prosecution was reopened, you should be able to apply the previously paid notice of appeal fee according to MPP 120401. So, this slide presents some points on the desirability of the program. As I noted, it helps save costs before preparing an appeal brief. It might secure allowability or reopening of prosecution. And it still allows for the full normal appeal process to happen if the conference review is not successful, and also it is free. So there's not an additional charge by the PTO for you to engage in this process. And I have a quote here, what examiners are saying, at least this was one representative examiner. The examiner said, "I don't know why you wouldn't use it. It's a way to save the client money. You'll get the same review with this or an actual appeal, so it's cheaper. If it's cheaper, it makes sense." And I agree with that. Lastly, this slide provides some citations to resources about this program, so you can take a look and learn a bit more. And I am now going to, we have another polling question. So for those of you seeking CLE credit for this webinar, again, please note the one-word phrase that appears on this slide. And enter it, please, into the WebEx poll question module. And you need to complete this and the previous one in order to confirm that you actively participated and that you're eligible to receive CLE credit. So thank you. And with that, I will turn things over to Brett for the final section.
Thanks, Larry. Again, we'll leave this up for a few more seconds. The poll will stay open even after we leave this slide, so we may advance off this slide shortly to try and make sure we cover everything within the allotted time period, but feel free to keep entering in your polling results while we move on. Okay, so our final program that we're going to discuss is the motion to amend pilot program. This is a little different than the previous programs in the sense that so far we've been talking about programs in connection with patent prosecution. This is a program that applies after you've received your patent, and if you're involved in an AIA trial, so an IPR, a PGR, or a CBM review. So what is this program? Well, it's designed to provide preliminary guidance when a patent owner files a motion to amend in an AIA trial, and I'll give a little background on how that process works outside of this program as well, for those of you who aren't familiar with motions to amend or AIA trials generally. And it also provides patent owners with an opportunity to file revised motions to amend during those trials. The official objective of the program, which was stated by the Patent Office when they put forth this program in their request for comments, is pretty generic. They basically said it's to provide an improved amendment practice that's fair and balanced. I believe the impetus for this program is because there were very few motions to amend being filed, and of those that were filed and decided on the merits, very few were granted. Only 5% decided on the merits were granted or granted in part since 2016. So this program is designed to hopefully increase that number. This pilot was introduced on March 15th, 2019, and the plan is for the Patent Office to reassess it after a year. So in the very near future here, they should be considering how this program has gone and whether to renew it to continue on in the future. So some background on AIA trials and motions to amend. AIA trials involve two parties, a petitioner and a patent owner. The petitioner is instituting the trial or initiating the trial to challenge the validity of one or more claims in a patent, and the patent owner is defending the validity of its claims. As part of the process of the AIA trial, the patent owner will have the opportunity to file a motion to amend where they can either cancel any challenged claim if they feel like it's not worth fighting for, whether they feel they're going to lose or for some other reason, or they can propose a reasonable number of substitute claims for any challenged claims. The presumption is that a reasonable number of substitute claims is a 1-to-1 ratio. So if you're providing one substitute claim, then it should be canceling one claim in its place. But that presumption is rebuttable. And the substitute claims cannot enlarge the scope of the claims or introduce any new subject matter. So when the patent owner files its motion to amend, it needs to identify the written description support for each substitute claim and explain how it does not enlarge the scope of the claim. After a motion to amend is filed, the petitioner will have an opportunity to oppose the motion. The patent owner will get to reply to that opposition, and the petitioner will get a chance to file a surreply. After all the briefing is completed, the PTAB will evaluate whether the motion to amend meets the statutory and regulatory requirements and will opine on the patentability of the substitute claims when it issues its final written decision in the trial. But it will only do this if necessary. So a lot of motions to amend are filed on a contingent basis where the patent owner will say they only want the amendments entered if the PTAB finds the underlying claims unpatentable. So if the PTAB finds the underlying claims to be patentable, then there's no need to opine on the substitute claims in the motion to amend. So that's some background on motions to amend. Now the pilot program, how it works is it gives the patent owner two additional options that it previously did not have. And the patent owner can choose one of these, both of these, or neither of these. The first option is that the patent owner can choose to receive preliminary guidance, and the guidance is issued by the PTAB, and it's guidance on its first motion to amend. The second option is that the patent owner can choose to file a revised motion to amend. This can be in response to the PTAB's preliminary guidance if the patent owner elected option 1, as well as the petitioner's opposition, or if the patent owner did not elect option 1, it still has the option under this pilot program to file a revised motion to amend in response to the petitioner's opposition. The guidance, if the patent owner chooses to receive it, it takes the form of a short paper. It provides discussion on whether the motion meets its statutory and regulatory requirements. It also opines on whether the petitioner in its opposition has established a reasonable likelihood that the substitute claims would be unpatentable. Now, the guidance is not binding when the board issues its final written decision. It can change its mind, come to different conclusions, but it can be helpful to both the patent owner when determining how to improve its motion to amend if it decides to file a revised motion, and it can be helpful to the petitioner as well for strengthening any unpatentability arguments when it files its response to the revised motion. So to show how this fits into AIA trials, here's a timeline. The top timeline is generally an overview of the procedure of an AIA trial. It will be instituted, and the patent owner has 12 weeks to file a response. The petitioner gets 12 weeks to reply to that, 6 weeks for a patent owner to reply. 6 weeks later, there's some motions before an oral hearing, and then a final written decision is issued by the board at the 1-year mark. Now, on the bottom path shows how the motions to amend fit into this overall process. The first motion to amend is filed with the patent owner's response at the 12-week mark. This is where the patent owner will elect to receive preliminary guidance if desired. If they do so, the petitioner will provide its opposition to the motion and its reply at the 12-week mark. And then the gray circle, or the gray oval here, represents the change in the program. So if the patent owner elected the preliminary guidance, it would receive it no later than 4 weeks after the petitioner's opposition. And this would be the non-binding guidance provided by the PTAB. Now, at this point, the patent owner can proceed as usual under normal AIA practice. The patent owner can file a reply 6 weeks after the opposition. The petitioner will file its reply. The oral hearing will occur at its normal time, and the final written decision will issue at its normal time. However, if the patent owner elects to file a revised motion, this kind of derails the schedule a bit, as we'll show in the next slide here. If the patent owner decides to file a revised motion to amend, it does this at the same time that its reply would be due, or is due, so 6 weeks after the petitioner's opposition. Now, there's a bunch of additional briefing that occurs at this point. So now the petitioner gets an opportunity to oppose the revised motion, and then there's some reply and surreply, and this is really compacted down. It's much slower, or it has to be done much faster than the standard timelines. Normally, the petitioner gets 12 weeks to oppose. They only get 6 weeks, and they would normally get 6 weeks to file their surreply. They only get 3 weeks. So there's some potential strategy here by the patent owner to, in its initial motion to amend, kind of hold back its stronger amendments and then put those into the revised motions to amend to kind of handcuff the petitioner and give them much less time to really digest and respond to the motion. Another outcome here is that the oral hearing ends up getting delayed an additional month, so it occurs at the 10-month mark instead of the 9-month. But to account for this, the final written decision is issued only 9 weeks after the oral hearing instead of the 13 weeks, so that the trial concludes within the statutorily required 12-month period. So that's an overview of how the pilot program works. In order to evaluate whether or not it works, well, it's pretty early at this stage. One thing we've noticed is that there were 87 motions to amend filed in 2019, which is the highest that we've ever had. The previous high was 68 back in 2014. So it does seem to be encouraging more an increased filing of motions to amend. It's still too early to tell if this program has improved the grant rate at all. Because these trials take a year to proceed, we're still waiting on final written decisions in the trials where this program has been participated in. So we don't really know yet if it has had any effect on the actual grant rate of motions to amend. So here we have a couple of resources for anyone who's interested for additional information on this program. We're a little bit past time here, so I'm going to wrap it up. Our last slide here, we've got, as Larry mentioned, there are some former programs that we had planned on discussing. The first 3 are programs that are fully implemented and no longer pilots, either because the Patent Office found them to be effective at what they were set out to accomplish, or participants found that were very receptive to them. These are the CUPIDS program, the Ombudsman program, and the Trademark Post-Registration Audit Pilot Program. There are a number of discontinued pilot programs. They were discontinued for one reason or another. Maybe they didn't do what they set out to do, or people were not happy with the way they were implemented. So those are no longer in practice, and those include the Post-Prosecution Pilot, or P3 program, the Expedited Patent Appeal Pilot, the Peer Review Pilot, or Peer-to-Patent Pilot, the Glossary Pilot, and the Extended Missing Parts Pilot. If anyone's interested in receiving more information on any of these, feel free to reach out to us offline. So since we're past time here, I'll just go ahead and wrap it up. If you guys have any questions, here's our contact information. Like I said, feel free to reach out to us. For those of you who submitted questions online, we tried to address those in the WebEx panel. For those ones that we weren't able to get to, we plan to reach out to you offline to address those questions as well. So with that, we'll conclude our presentation, and thank you all for attending.